was required. And then they say, well, reasonable detailed complaint must be required, and the amount of damages. So they admit in their paragraph 9 that they're supposed to provide the amount of damages, but it was not provided. Now they cited 2 cases, City of Houston case for the proposition that it set a formula for value of mental anguish. But that case talked about another person's pain and suffering. It had nothing to do with a DTPA claim. It's not relevant. That case was a car wreck case. The car went into the ditch. The city got sued for negligence, but the case does not say anything about a formula for mental anguish damages. Now, number 2, the Norris versus Jackson case, which they cited, that dealt with evidence whether or not it was sufficient to establish the customer suffered mental anguish as a result of deceptive business practices. Here, we're not even at that point. We're just trying to determine whether the plaintiff's DTPA notice was sufficient. It was not sufficient because the amount of mental anguish damages was not specified in their notice. So in summary, the actual DTPA notice that we received was on November 2nd. It was backdated to October 6th. We never received it until November 2nd.
I get it. Ms. Cadillac, why didn't you send it on November?
Well, Your Honor, first, we do not believe our original letter was deficient. We rewrote the letter on October 6th, and my paralegal put it in the e-file. I learned this morning, and I guess she learned on the 11th, or I'm on the 2nd, and didn't advise me that she forgot to hit send on October 6th. So that is why the date is October 6th, because even though we do not agree that our original notice was deficient, we believe case law supports it is too difficult to make a number for mental anguish this early on. We asserted that in that letter. We went ahead and updated it. And then as you can see, it's dated the 6th because I believed it had gotten filed. Mr. Clark filed something the same day. And that is why I thought it was ours. And so unfortunately, I didn't learn until today, that it wasn't filed until the 11th. However, he had sufficient notice. He knows pain and anguish is part of this case. Our letter addressed that. It did not give a specific amount, but your Honor's order was not meant to dismiss every DTPA claim that we have simply because we didn't put an amount on that. We can find economic damages relatively easily by going and figuring out an approximate value of the property and so on. It is incredibly hard to define mental anguish, and that's something that usually comes out through the discovery process and through questions asked by counsel. So that's why we don't think our first letter was deficient. As to updating the letter, again, I thought that was sent on the 6th, and unfortunately, the send button didn't get clicked until several days later, well, weeks later. We weren't meaning to delay or ignore the court order or anything like that. That was a mistake. She thought she had hit submit, and it was just still sitting there in the e-file outbox.
Okay. It was never my intention, and I don't remember how the order is worded exactly, that you guys would have had to specify an amount of mental anguish. I don't think that's required, and that was not my intention. To the extent that you guys have read it that way, that was never my intention. I would never order someone to specify an amount of damages for mental anguish. I agree, it's too speculative, and so the court is going to go ahead and deny the motion to dismiss. Do you guys have anything else today?
Your Honor, opposing counsel had requested attorney's fees against us.
I'm not going to give attorney's fees. I do want to let you know, I saw that somebody filed, I don't want to hear argument on it, but somebody filed some kind of motion to reconsider for next Monday, I think. Is that right?
Correct, Your Honor, we did.
Who is that, you, Mr. Gonzalez?
Yes, Your Honor, with Mr. Hikari as well.
Okay. There is a good chance that hearing is going to get canceled because Wait, is that set for this Friday,
Uh,
next Monday?
Brandon, I believe it's set for the,
I thought it was the 15th.
the 15th. I mean, the 19th.
Today's the 5th.
Yeah, today's the 15th.
No, not today. I'm checking.
Anyway, let me look. I just had this up. Let me see. It's next Monday. There's a very good chance that hearing is going to get canceled because looks like I may be in trial that day. Do you guys want to talk about it today, or you just want to reset the hearing, or you just want to kind of wait and see?
We weren't prepared to present today, though, Your Honor. I mean, we
That's okay.
if you could diligent, I mean, how long of a setback would we be off of next week, next Monday?
I'm not for sure. I mean, this case that is going to knock out your hearing has been reset so many times, and so I think it's going to go. We just set it and had a pretrial and the whole bit. So there's a chance it may not get reset, but if it gets reset, it'll probably be a few weeks. Just kind of, that's what my schedule's like, but we're just kind of getting backed up with all these jury trials now. So anyway, just wanted to let you know if there's something urgent, I'm glad to chat about it now, but if it's not urgent, then we can just reset it if we need to. And I haven't read that particular briefing, so.
I'm not prepared to discuss it today either, Your Honor, but
Okay.
whatever works for the court. I am one of the rare people that works the day after Thanksgiving, so I don't know if the court is open that day.
The court is not open that day.
Okay.
And you should take the day off. You don't need to work that hard.
I like that day because nobody's at work, and so I can get a lot done.
I'll be working that day, Judge.
Mr. Clark, you need to take the day off.
Your Honor, I'm going to
I'll
tell
set up
everyone
my Christmas tree that day.
Mr. Clark, you and I are ordered to take a day off, okay?
Yeah, order to take a day off. Judge Hoffman finds out you're going to be contempt of Christmas or the holidays.
Judge, I have since we're all here today, I have a matter that I was curious. We're now, Mr. Barrett's case is now in abatement, I understand, for the claims against his client. I guess all the claims against him for 60 days. And I'm wondering, that could be awkward if, like, my client was deposed and then Mr. Barrett wasn't participating in the case. Would he be subject to another deposition? And so I'm just wondering if that abates the whole case, or
It only abates the DTPA claims. You guys, I mean, I'd suggest you guys just work it out. I mean, if you can't, I'm glad to. Let's say that, Mr. Barrett says, "Hey, look, you're going to have to do this deposition twice because I'm not going to be there because the case is abated because he only has DTPA claims against them." Then bring it to the court's attention. I'd be glad to, just work with each other on that. I think that's something you guys should be able to work out.
Your Honor and Ms. Cadillac, is it our understanding then that the two DTPA claims are abated until when? I guess that's the question.
That was my question also.
Ms. Cadillac.
I thought it was 60 days, Your Honor. So I think December 1st, if that is 60 days, or maybe December 4th, somewhere in there.
Because the order was dated October 1, it was signed October 6.
And then when the letter was sent, when the original letter?
The 4th.
October 4.
October 4th. So yeah, it would be so what, January 3rd or 4th, something like that. Isn't that no October?
December, I think.
December, sorry, 3rd or 4th, yeah.
So Lauren, would you agree that it's abated up and through December 6th?
Sure, yeah, that works for us. Mm-hmm.
Now,
do you guys have a trial setting on this case?
I don't think so, Your Honor. And in fact, I'm glad you brought that up. Would you, I'm sure you would like us to coordinate a scheduling order amongst ourselves.
Is this a level 2 case or level 3 case?
I believe it's level 2.
Let me look it up.
I'm looking at it, Your Honor, the plaintiff's original petition, paragraph 1, it's a level
Yeah.
2.
So let me go ahead and set this for trial. When was this case? When did the defendants file an answer on it?
Well, my clients, I believe we filed an answer, Ms. Cadillac, was it in August?
Yes, I believe so. That's right. We agreed to when it would be. I think it was mid-August.
Yeah, mid-August, because there'd been a staggering of service on defendants.
That's right.
When did the last defendant file an answer?
He
there's
actually
one in
has
some.
not filed one, and the final defendant's answer is due on the 21st, I believe, 22nd.
Of November?
Yeah, it's the next Monday. Is that the 22nd?
So you guys want to set this for trial maybe in August? What do you think?
August of 22, Your Honor?
Yeah.
I could definitely do that. I could not do September or October of 22, but I can do August for sure.
Okay.
What would be the date? Because my daughter's getting married on the 20th, but that's so I'll be out a few days before.
Oh,
that.
Congratulations.
Yeah, that's cool.
Yeah, she's taking the bar earlier.
Oh,
June.
Yay!
Yeah, so maybe she'll get to be on this case.
There you
oh,
go.
that would be so exciting, Mr. Clark. Oh, that would be great.
Well, she was an intern. She's met the judge and
What
yeah,
if we did early August and you could get it off your plate and really go enjoy your daughter's wedding, which I'm sure you're paying for.
August
Probably
2nd
either
or
way.
9th? You want to do August
any of
2nd?
that's fine.
August 2nd?
Does that work for everyone? Mr. Akari, Mr. Gonzalez?
I believe so. Mr. Corey, I yield on that one with you.
I have one in the 162nd and one in the County Court of Law number 2, which is a jury, which I don't know. I guess we'll be doing juries by that time.
Well, we're doing jury trials now. I've tried eight cases,
Oh,
at least
wow.
8.
Oh, have they all been Zoom?
Nope,
Oh, okay.
in person, all in person.
And do both sides have to agree or just
Nobody's doing Zoom.
do both sides have to agree to do it live? Jury?
No,
Okay.
no, you just go to trial.
Okay.
Those dates do work for Turek.
And for my clients too, Sunset Equity, Easy Financial, you mentioned August 2nd, that would work.
Well, you usually do. And this is a non-jury, I believe, if I'm not mistaken.
Correct.
Actually, I'm looking better any day but the 2nd or the 9th. I've got conflicts with older cases is the problem on the 2nd and the 9th. I don't on the 16th or the.
When is the wedding though?
Oh, it's the 20th. But I mean, that's a Saturday. I'll be walking the bride down the aisle. There'll be a rehearsal dinner the night before,
Yeah.
but at a restaurant, I don't even know where it'll be. And so I can do 2 things at once. My daughter won't be there to assist me, but maybe on the 23rd or the 30th, I wouldn't have a conflict on those 2.
I have a trial set for the 23rd, but I could definitely do August 30th.
August 30th works for us as well.
Is that a Tuesday?
Yes, sir.
And with my busy schedule, I always have some conflict, but I'm sure this is a more important case. It's a multi-party case. I'll just explain to these other judges. So, and one of the judges I noticed is on her way out anyway. So
Who's on our way out?
I think Maricela Moore is running for.
Oh yeah, Court of Appeals. Yeah.
Oh.
Yeah, so
Okay.
that I'm using that term. She'll still be around, but on a different floor. No,
Too much probate to say on your way out myself.
yeah.
And the 30th works for my client as well, Your Honor.
Give me 1 second.
Actually, the 30th is great. I do have another case, but it's before you, Judge Hoffman.
Hey, Bob, the judge had to take a break for a second.
It sounded like a dog issue.
Mhm.
My dog is behaving himself right now.
So, Mr. Clark, are you paying for this wedding?
Yes, and I've had several payments, and the reception's going to be at the Adolphus.
Oh,
Nice.
It's gonna be a church.
that's gonna be great. Good for you.
Yeah, it's gonna be at the same church where she was christened, the same room. So that'd be.
Oh, that's so
Yeah.
cool.
Yeah.
Oh,
Hey, congratulations.
Thank you. Judge, on the 30th, I have another trial, but it's before you. So you can only be one place at a time.
Only one place at once. Okay, we'll do the 30th then, guys.
Okay. I guess
All right, we'll go ahead and reset this to the 30th. Anything else, guys?
that's it.
Not
Thank
today,
you,
Your Honor. Thank you for your time.
Oh, and did you submit an order for me on this, Ms. Cadillac, or?
I did, and we emailed it to Rhonda as well.
We're going to have to revise that order, Lauren.
Yeah, you're gonna need to scratch.
Would
Yeah,
you resubmit a revised order to me?
I can and I will.
Thank
Yes.
you.
Okay. All right, thanks, guys.
Thanks,
Thank you.
Judge.
Your Honor.
And make sure that it says at the beginning of the order that this was heard on November 15th, 2021, instead of on this day.
Okay.
Okay.
Perfect.
Thank you, guys. And
Thank
Thank you.
Tony, our next one, I think, is at 3 o'clock.
Okay, Judge, I'll be back. I'll be ready.
Thank you. Bye-bye.
Right.